A very good evening to all of you present here. I, Parashit, a member of Legal Vidya, I welcome you all on the 12th class of our 45 days certificate course on advanced legal drafting by Legal Vidya. So, without further ado, let's warmly welcome our honorable speaker, Ms. Shivani Gupta ma'am, to the virtual stage. Welcome, ma'am.
Good evening, Legal Vidya. Thank you for the warm welcome. Good evening, participant present over here. I'm just sharing a screen. Wait for a second, and then we'll start today's drafting session. And only two students shared me the draft that I have posted in the group yesterday. So those who didn't prepare, do prepare as it will be like a practice. You have done the practice for the draft. I'm just sharing a screen. Wait a second. Today's topic is about the SLPs, that is the special leave petition that is being enshrined. Wait for a second. Okay. Today's session is about the SLP, and SLP is provided under the article number 136 of the Constitution of India. Does the screen is visible to you all? Okay. Uh, SLP, we will discuss under article number 136. SLP particularly is an expression that is taken from the government of India in 1935. SLP is also a kind of a petition that is being filed under the Supreme Court, and that provides the very special permission just to the aggrieved party to be heard in the apex court and against any judgment, order, or the decree. Before jumping directly into the draft of the SLP that is provided under Article number 136, we will discuss a little bit about the provisions. As we all know that the part 5 of chapter number 4 of the Constitution of India. Wait for a second. Yes, as we all know, upon the screen it's also mentioned. Okay, one of the student has shared the draft. That's why so much messages for pinging. Yes, so under the chapter number 4 of part 5 of the Indian Constitution, that is being titled as the Union Judiciary, that particularly deals with the Supreme Court's power, Supreme Court jurisdiction, Supreme Court's functions. The person are just like, okay, there are some of the aggrieved party, not persons particularly, they are just like they are not satisfied, either satisfied or they are just like the aggrieved of the judgment that is being passed by the high court, and then in those cases article number 136 empower the Supreme Court just to apply for the appeal, and not the but it's just a provision that is being available to the aggrieved party, but it's not like a right raise here. Okay. And article number 31, 36, it's just a very wide article that provide it like it doesn't limit itself into a particular type of case only, but it's just a lot more kind of a case being covered under the ambit of article number 136. This is what the introductory aspect of the article 136. Now, what is SLP especially? Article number 136 states about what? Article number 136 clearly states that there is a aggrieved party, and there must be the aggrieved party have to take the special permission to be heard in the Supreme Court of the country against any judgment, any determination, any sentence, any court or any tribunal in the territory of the India only, or that is the aggrieved party of any order. A special petition doesn't allow or kind of a cases can't be heard are military cases or the court martial cases. Next is there are certain other provisions also that the exception to those are is taken from the Constitution of the UK. And SLP is not a right guarantee to the citizen of India, but it's a privilege guarantee. It's just not like a person can claim somewhere that okay, as per the article number 36, he can file the appeal. Now comes what appeal and can also be filed the if the High Court sometimes refused to grant a certificate of fitness for the appeal under article number 134A. So this is the background of the SLP. Now we will come to the another aspect. Yesterday I have shared you the I think PDF of the same. So you might have studied that also. Now, it's a question of law. In the case of a SLP, it's also a question of law. And then here I mentioned a case law, very famous case law. Case law. The case law name is Saurabh Jain and another versus ABP design, ABP design and another. So this is a very leading case law of the SLP, and in that case, Supreme Court held that new ground can be added, and where a question is there, the question is about the law, what the law is, and if the petition is rejected somehow, then what would happen? In this case, under the case name under the Saurabh Jain and another versus ABP Designs and another under 2021, the new ground being added. Now there is also a time limit for filing the SLP. Like we have studied the time limits for filing petition, application, or the appeal under the Limitation Act. They particularly and for the civil criminal procedure code, these are mentioned in the sections only. So likewise, that also SLP for the SLP also there is a time limit, and the time limit is just like it must be filed within the 90 days. Sorry, 90 days from the date of the judgment, or it must be filed within the 60 days from the order of the High Court. If you're refusing to grant the certificate of the fitness for the appeal to the Supreme Court. Now there are certain requirements for filing the SLP. Certain requirements can be this SLP must contain all the facts that are being necessary for the Supreme Court, whether it should be granted SLP or not. So there must be the unnecessary facts, and there must be like the court must be convinced to the board like okay, this is the reason, and that's why we should grant the SLP. Now the petition to be signed by AOR, that is a very basic thing. I think everyone must be acquainted with. There should be a declaration by the petitioner stating that there is no other petition filed in the High Court. There should be a declaration by the petitioner that is stating that the annexes produced along with SLPs are true copies. Another is SLP must be attached with the judgment against which the appeal need to be filed. So these are the basic requirements, prerequisites that are being adhered to. The aggrieved party must be adhered, or the advocate on record who is filing the SLP on the behalf of aggrieved party must be adhered to. There is another question asked in the comes in the mind that what about the tribunals? Those judgments are also allowed to grant especially petitions. So the tribunals generally in the general aspect, when we see Supreme Court is the only body that is allowed to grant a especially petition. But sometimes and students, what I am discussing right now is everything that is being mentioned in the PDF. Nothing else I am discussing here, and everything is just being provided to you and showing up on the screen. Meanwhile, if you face any type of a query, then please put the query in the chat box. I will take all the questions at last of the session today. Now, what happened? It's when sometimes tribunal recognized by the law can also grant the SLPs, and if the tribunal is granting the SLPs, then the tribunal must possess the power to resolve the legal issue that can arise among the citizens of India. And the tribunals must have the same power as the court possesses, like calling a witness, examining the witness on oath, reviewing the evidences, and reviewing the evidences and cross examinations of the witnesses and so on. What about the provisions of the SLPs in the civil cases? So in the civil cases also the SLP scope is very wide, and the procedure is for filing any kind of SLP in the civil court is given under the order number 21 of the Supreme Court rules. There is another where that you must refer to, that is the Supreme Court rules 2013. For practicing or litigation in the Supreme Court, you have to follow. Then form number 20 is required, that is required to file before the Supreme Court for filing the SLP. The list of dates in the chronological order with the events related to the dates must be attached. The petitioner wants to present more documents which are not in the part of the records of the lower court, he must states the reason that why those documents are not produced in the lower courts and why the documents are being producing here. Okay, and English versions of the relevant provisions of the Constitution, relevant provisions of any statutes, ordinances, rules, regulations, bylaws, order. And those provisions that are being referring to the impugned judgment or order shall be filed with the appendix to the SLP. If the notice is served, then the petitioner must serve the notice also. Now, another thing is in the case of a criminal cases matter, the Supreme Court must not interfere in the finding of the fact. There are certain guidelines being issued regarding the SLPs and their and the case name was Dalveer Kaur and other sources, State of Punjab. It's a case of a 1976 where the Supreme Court will never review the evidence unless the High Court has made an error in the process of law. Next is Supreme Court also interfere in the cases where inferred wrong conclusion from the evidences, then only the Supreme Court may also interfere. Next is interfere, the Supreme Court will interfere in the cases where the High Court has violated the principles of natural justice. So these are the some of the basic concepts, basic backgrounds. Now we can talk about what is the role of granting the SLPs in the SLPs by the Supreme Court. Okay, so one thing you have to always keep in mind that Article number 136 applies to judicial decisions only. It doesn't apply to any kind of executive or administrative decision. So this is a very important thing you have to keep in mind. Then there are two stages are there where while the court is hearing the petition for SLP to leave, next is the petition is granted. Then it will be converted into the appeal. So these are the two stages. Language judgment are like Pritam Singh versus the state and the Tej Kumari versus CIT. So this is the basic law behind the SLP that is being discussed. Now, in regarding any law or regarding any provision, Article number 136, anyone have any query, then let me know, put in the chat box, else I am sharing the draft. If you get the law, what is article, overall conclusion of the fact is that Article number 136 only discuss about the provisions of law for the SLPs. Article number 136, we have to go through in the Barrett. Already I have mentioned each and everything on the slide. I hope you got the article number 136 that is providing the provisions for the SLPs. If you got it, then please give some thumbs up, else I will share the today's draft of SLP. Okay, yes, okay, Shrishti, okay, and Vijay. Wait for a second, sharing another screen. Okay, I'm just sharing another screen. Does the screen is visible to you all? I think it might be visible. Okay. Thank you. So this is the draft of the SLP under Article number 136 of the Indian Constitution. Now we will discuss the draft. First of all, go through the draft. I have shared this draft yesterday in the group, so I think you might have opened the facts. This is a sample draft for the article number 136. And once again, I will say, though there is no as such rule, hard and fast rule. Okay, you have to mention these words only. You have to mention these words only. There is a particular drafting criteria. Drafting is like a crafting. More you draft, the more you will learn. So this is the thing being followed while we draft. That's why I asked you to share the bail application, but unfortunately only 2 students share me. No worries. Looking forward, today I will give you one SLP. If possible, please draft that. That would be easy for you to just practice. Okay, so this is the sample draft of the SLP under article number 136. We will write, and this is the heading that is being mentioned on the top. So this is not you need to mention, but as for the file name, I have mentioned, and I have also mentioned it. It's a draft. And now we will start with in the Supreme Court of India. Supreme Court rules order number 21, rule 3, clause 1, part 1 and clause A. Now criminal appellate jurisdiction, it's a SLP about the criminal appellate jurisdiction, SLP. Now, under the Supreme Court rules, order number 22, rule number 2, clause 1, SLP criminal number is this, and this is of the year 2021. Now, against the impugned judgment and final order that is being dated and passed by the Honorable High Court of the Uttarakhand at the Nainital, in the case number is this. So, this is the way we have to mention that okay, this judgment was this, the court was this, the court was this, and the criminal appeal was this number, criminal revision was this, and sorry, ma'am, my internals are going on, so I didn't get time to prepare. No worries, Saurabh. Yes, it's a time of internals only. I can understand. No worries. When the course is about to end, when you get free, then we should start drafting. Would be for the practice of you only. Now, this is the basic format that is being prepared. That on behalf of that, the SLPs are being prepared. Now, we will mention about the parties. It is and the SLPs between the position of the parties, and in this honorable court I have mentioned it twice. Remove it. So first is the petitioner and the second is the respondent. The petitioner is Raman Rawat and versus state of Uttarakhand to the police station Vasant Vihar, Dehradun. Now we will start mentioning two honorable chief justice of India and his companion judges of the Supreme Court of India. Humble petition of the petitioner above named Moon respectfully show it. So these are the very basic things that you have to mention. I am today again making you acquainted with is that these are the basic things and these are the basic info that is required to mention in each and every kind of appeal application or anything or petition that are we going to file in the courts, and you have to follow certain rules for disclosing the informations, or what's the relief you want from the court, or what's the fact of the case, what's the remedies you are already availed, or what are the remedies you are aggrieved of you didn't get, what are the problems, what are the trans. So these are the things that is being mentioned, and the vocab is same. Now look, you just only analysis by yourself. The draft today I am sharing is somehow similar to the draft I have earlier shared, because somehow it's being mentioned like okay, not honorable chief justice of India, so another session judge is there and the companion judge is removed, okay, and the district court or session court Moradabad or the Indore or so ever, and then the humble petition regarding the same and most respectfully show it. So these are the basic drafting criteria that is being followed. Now, what first point we will mention it like that the petitioner is the resident of the Uttarakhand at the Dehradun, and there is a being case registered that is being case number 5585 2021, where the Supreme Court dismissed the anticipatory bail of the that is being filed by the petitioner. Now, what happened? There is a question of law. Another part is that the question of law. Question of law is first of all, first thing. Now read it carefully because these are the facts that are being important, and you have to be aware about if your question a court is questioning you, then you have the sufficient paperwork, research work, or the documents available in the support of your argument. Now the first thing is when the rejection of the bill was correct in terms of the law laid down by the by in the catena of the justice by this honorable court, whether the rejection of the bail application was correct or not. First question is this. And next question is whether the Honorable High Court ignored the fact that the matter has been settled between the parties and the most of was of civil nature and didn't require any criminal proceeding. Then why there is no as such grant of the anticipatory bill, why there is a rejection of same. And when the Honorable High Court failed to appreciate that the petitioner did not commit any offense, nor did he conspire to attempt and act as alleged in the complaint, the where the so High Court failed to do so or not, whether the Honorable High Court erred by ignoring the settled principles of the anticipatory bail jurisdiction that the petitioner is unlikely to abscond or misuse his liberty while he was punished in the jail. Now, another thing that we have to mention, I have mentioned under the point 3 also, declaration in terms of the rule number 3, part 2, clause number 2. The petitioner stated that he has not filed other petitions seeking the leave to appeal has been filed by him against the impugned judgment, and the order date is being passed by the High Court of Uttarakhand at this date. So this is the declaration to be mentioned in the Supreme Court for the same. And now the declaration that is as per rule number 3, clause number 2. Now the declaration is in the terms of rule number 5. The annexer P1 and P2 filed along with the specially petition are the true copies of the pleadings documents which formed part of the records of the case in the court tribunal below, against whose order the leave to appeal is sought for the petition. Now there are certain grounds that we need to mention, that is the leave to appeal is sought for the inter alia. Following grounds are there. So these are the grounds that you have to be mentioned very carefully. First of all, the ground we can say is Honorable High Court erred. This is the term erred. ये mistype हो गया है in taking into the account that the basis the documents prima facie the petitioner has not committed any offence as alleged against him. The Honorable High Court ignored that the petitioner is innocent and has been falsely robbed in the entire case, because the High Court erred in the noticing that there is no ingredient in implicating the petitioner in the constitution of the alleged offence, and the iota of the evidence has been put on the record to make out any. And there are certain other grounds available to leave to the application then in the sort for the inter alia, then you can mention those also. There are certain grounds for the interim relief. Interim relief is like, okay, if temporary relief during the pendency of the case in the court, the petitioner is all just ready to abide by all the conditions that is the Supreme Court, Honorable Court may impose while granting. Another is the petition has a good prima facie case and balance of the convenience lies in his favor. So these are some of the grounds that are for the interim relief. Now comes the main prayer. Main prayer is very important, and that discuss about therefore the light in the light of the our petitioner most humbly submitted that the Honorable High Court may be pleased to. These are some of the vocab and the languages that you use during the mute court also. If you remember, when you're doing the prayer, then you are just like the petitioner in the Muherin most humbly submits that the High Court may be pleased to grant a special leave to appeal against the impugned order. Final order date is number this that is being filed by the Uttarakhand High Court under criminal appeal number this, criminal case number this. Pass any order, or there's the Honorable Court may deem fit things so and proper in the facts and circumstances of the case. So these are the some of the things that are the main prayer includes. Now comes the interim relief. Interim relief is when in the wherefore in the right of a petitioner most humbly submits that it may be court may be pleads to grant anticipatory bail, because at last we are looking for seeking to grant the anticipatory bail. So the regarding that we have mentioned it again. Anticipatory bail can be granted to the satisfaction of the additional judge Dehradun during the pendency of the SLP pass any order, or as the High Court may deem fit so properly. Now that is being filed, person accused name is there, aggrieved party name is there, and then the place is there, and the on which file it is being drawn, advocate who is the advocate on record, and the who on which date it is being filed. Now and there is another thing that is being mentioned with the SLP, that is in the Supreme Court of India criminal appellate jurisdiction. There is a certificate also being produced. Certificate in the matter of particularly the who's the matter of is who's the case name. Then the certificate would be read as it certified that SLP is confirmed only to pleading before the High Court of the Uttarakhand whose order is challenged, and the documents relied upon in these proceedings. No additional facts or grounds have been taken for the relief. Certified that copies and exams are being attached. There are necessary answers to all the questions of the law raised, and certificate is already particularly given. I have also mentioned this on the basis of instructions that is being given by the petitioner person authorized by the petitioner who is affixed in the support of the SLP. Now that will be filed by the advocate name is there, then the date and place is there. Then we will file what are the particulars of the documents regarding the index, what is the page number where it belong to. And if there is any remark, then for example, in the part A, we have declared the particulars of the document. In the part B, we have declared about the contents of the file. Content of the file include what? These are the very basic contents of the file. It's a court fees, it's an officer report on the limitation, it's a limiting performer, it's a cover page of the paper book, it's indexing of the recording of the proceedings, and so on. So this is all the about the sample draft of the SLP. I'm not denying that there are many more things being put in the there are many more things being put in the SLP's draft as per the requirement of the case, as per the consequences, as per the events being happened, and as per the interim relief or the you are seeking from the court. But this is the basic draft, and you must be adhere to this draft. And while just drafting or crafting the SLPs, and anyone if have any doubt, please start asking, because this is all about the draft of the SLP. And today is the last session for the criminal drafting. From tomorrow, we will start the civil drafting. So if anyone having any doubt regarding the same, please start asking. Because it's like going a monologue session. I'm just speaking from here and no one is just asking anything or clearing any doubt. Yes, please, anyone, please come forward and clear your doubts regarding the criminal drafting. Regarding the SLPs especially. No one have any doubt. If the draft is clear to you, please give a thumbs up to me. Let me see how many of you are just acquainted with the draft of the SLP. Okay, Sanket. Only one student. 26 participants are there, including me and Legal Vidya. What about the other 24 students? Yes, please, anyone have any doubt? SLP can be filed. Yes, SLP can be filed in both civil and the criminal cases. And moreover, the drafting for the both SLPs is also the same. Yes, please just clear your doubts. Can new evidence be introduced through the SLP? Sony, there is a circumstance like if you are introducing the new evidence, you have to give the proper reason. And it's not never been safe to introduce the new evidence through the SLP. Evidences must every time be introduced during the process of trial. And that is not easy for you that you can convince the court, or you have to just mention the thing that this is the particular reason that you are introducing a new evidence, or this is the requirement like this now. Better to just produce the all the evidences at the time of trial. Sony, if your doubt is clear, then gives a thumbs up. Okay. Yes, anyone have else any query? Strange, people are just acquainted with the SLP draft. Okay, anyone have any query regarding the criminal drafting? I'm sorry. No one have any query? Then gives a thumbs up. "26 people are here. Is SLP filed only filed against a high court judgment?" Yes, Sony. SLPs are always against the high court judgment also, or any tribunal judgment is that. But for filing the SLP, now you need a certificate. Then it's important that it must be against the high court judgment. And for foremost reason, SLPs are filed against the high court judgment. Only I think Sony and Anmol and Saurav are studying here, or they are learning new things. By the way, if the SLP draft is being understood, you are all understood that, then it's very good thing. Yes, please come forward to clear your doubts. Because there is no such thing that I run the class for 1 hour and what I have to teach. Because SLP is all about how to draft the SLP based on the circumstances. And the litigation is more about you just start practicing, you just start taking the random consequences, consequential events, and you just start taking random newspaper news, and you just start using those facts and start drafting. Madam, could you please repeat again in brief what procedure requirement should be followed when a patient under article number 136? In brief, actually, what is the procedure? Procedure is very simple. If you are asking about, then you have to just draft the SLP. And procedural requirements is just like, first of all, you have to get the certificate from the High Court just to file the SLP. Then, and if you are not getting the certificate, then also this can be the one ground just to approach the Supreme Court for the same. And if you are right of any of the judgment, any of the order, or any of the thing like this, then also you can approach the Supreme Court. And the SLPs, you must have the drafted SLP with yourself with the certificate as per the Supreme Court rules. This is only the brief of the same. Yes, anyone else, please? And once you just gone through the article number 136 of the Constitution of India, you will be like, okay, so the drafting is much more important than studying the law for the same. Yes, anyone else? Rahul, I hope your doubt is clear. Okay, so today's task would like to give you. You have heard about the writ petitions also. How many of you heard about the writ petitions? Gives a thumbs up, please. Writ petitions. Okay, okay. So today's task is you have to write down any three differences, 2 to 3 differences between the writ petition and the SLPs. Did you got it? Difference between the writ petition and the SLP. Or if you think so that SLP is itself a writ petition, then please give the reasons and share to me. Then I would be like, okay, you have learned something. And SLP, for SLP, you can follow article number 134. Okay. So that's all for the SLP and the today's session. I think there is no need to carry the session to the foremost hours. And thank you so much everyone for joining. And please mention the difference between the both. Either 2 to 3 the differences are sufficient to understand the concept, and start practicing. Start take the random circumstances from the newspaper and start drafting everything. And from the tomorrow session, we will start the civil drafting. All set for the civil drafting. If any doubt in the criminal drafting, then please ping me or ask it out during the class. In Legal Vidya, if you are there, then we are done with the criminal drafting today, along with the SLP completion. We'll start the civil drafting from tomorrow. So let's wrap the session. Okay, then Vijay. And to share me the file photographs of the bail. I will check out them out and will give you the reviews tonight till 10. Thank you.
Thank you so much, ma'am, for such a wonderful session. And all the participants, kindly send your previous task on the anticipatory bail to me through DM. All the participants have to send your task by tomorrow 8 p.m. of the anticipatory bail. And the today's task you have to send after the 2 days. Srishti, okay, you can share to me. I can directly share to them. So we have also a record of how many students are doing the work. So kindly send the task to me, then I will send to my. Yeah, thank you so much, everyone joining. And now you can leave the session. Thank you.
Happy learning. Thank you. Good night.